Tort is a wrong that involves a breach of civil duty owed to someone else. It is different from a crime, which involves a breach of duty to society in general. If a person suffers a tortious injury, they are entitled to receive damages or money from the person responsible for that injury. This also includes injuries to reputation, economic, and emotional injuries, as well violations to the rights of property and privacy.
All right. Types of tort. There are several ways we can classify torts. However, it is easiest to divide into two: negligence and intentional torts. Our tort case type is that of negligence. It is the most common form.
In February 2011, Mr. Richard arrived at the University of Hong Kong. While on an escalator at campus, the moving handrail Mr. Richard was holding onto stopped moving, causing him to lose his balance and tumble down the stairs.
Procedural posture. Mr. Richard sued HKU Insurance Company, ABC, who bought a third-party action against Westinghouse. ABC moved for a directed verdict, but the court decided to let the trial continue. After hearing the parties' arguments, the court ruled that there was no evidence that the HKU had been negligent, and that the case could not go to the jury based on res ipsa loquitur, because at least one of the requirements for its application, that the injury-causing instrumentality was within the exclusive control of the defendant, was not met. Did HKU effectively have exclusive control over the escalator because the authority in control of a public area has a non-delegable duty to maintain its facilities in a safe condition?
Rule. The authority in control of a public area has a non-delegable duty to maintain its facilities in a safe condition.
Reasoning. Under PR law, 3 requirements must be met for res ipsa loquitur to apply. 1. The accident must be of a kind which ordinarily does not occur in the absence of someone's negligence. 2. It must be caused by an agency or instrumentality within the exclusive control of the defendant. 3. It must not be due to any voluntary action on the part of the plaintiff. The first requirement was met because an escalator handrail probably would not stop suddenly while the escalator continues moving unless someone had been negligent. The second requirement is also met. HKU effectively and had exclusive control over the escalator because the authority in control of a public area has a non-delegable duty to maintain its facilities in a safe condition. The third requirement is met because there is no evidence that Mr. Richard caused the accident. Solely because the handrail stopped and Mr. Richard fell without further evidence as to why or how the handrail malfunctioned does not give rise to an inference of negligence by HKU. The malfunctioning of an escalator presents a strong argument against the raising of an inference of negligence without additional proof as to the cause of the malfunction. Expert testimony is required to establish the basis for such an inference.
We can see that the plaintiff won the case, the reason being that the defendant was found liable for negligence. The standard criteria for determining the liability for negligence are: duty of care by the defendant to the plaintiff arises when one individual undertakes an activity which could reasonably harm another. Breach of this duty by the defendant to the plaintiff, negligence, when a foreseeable risk under the duty of care for one party harms another. Harm is actually found to be suffered by the plaintiff. Defendant cannot try to beep the court. Defendant's breach found to be the cause of that harm.
Hey, get these for me.
I ain't got no money. I got nothing.
Man, you owe me $2.
Eddie.
Oh my God! Oh my God! Oh, I'm hurt! Oh, ah! Oh, I'm suing y'all! Oh, I'm hurt! Oh, my neck! My back! My neck and my back! Oh, I want $150,000! But we can settle out of court right now for $20.
Man, get your punk ass up. It ain't even wet over here.
Hey, well, look here, man. Just give me $10 and I won't say nothing.
Get out.
As we can see, even though the malfunction of the escalator was not anyone's specific fault, the maintenance of the escalator was found by the court to be under the duty of care for the defendant. The plaintiff, therefore, had the right to receive damages from the defendant after the breach of this duty caused physical harm to the plaintiff.